Welcome to everybody. On behalf of the Center for Research on Law, Equality and Diversity and the Institute for Humanities and Social Sciences, I want to extend a very, very warm welcome to Professor Brenda Cossman. And we are hosting the launch of her brand new book, The New Sex Wars, Sexual Harm in the Age of Me Too, by NYU Press. Brenda, if you could just hold it up, it's like hot off the press, right? And I think you've just only received your copy just a few days ago. So congratulations to you. The book, of course, is very timely, a publication mapping out feminist debates on the Me Too movement that focuses on North America. And it responds to really challenging questions such as how to regulate sexual harms, but most importantly, how to get beyond some of the highly polarized and often very antagonistic debates between feminists on sexuality and sexual representations and the use of the law. Brenda Cossman is professor of law at the University of Toronto, and until recently, she was the director of the University of Toronto's Mark S. Bohem Center for Sexual Diversity Studies. She teaches and publishes in the area of family law and feminist and queer legal theory, and her books in this area also include Sexual Citizens, the Legal and Cultural Regulation of Sex and Belonging, and the earlier co-authored book, Bad Attitudes on Child Pornography, Feminism, and the Butler Decision. We're also very delighted to welcome, as our discussant for today, Dr. Tanya Serissier from Birkbeck, where she is a reader in feminist theory in the Department of Criminology. She has a very distinguished publications record and includes her critically acclaimed book from 2018, Speaking Out, Feminism, Rape, and the Narrative, and Rape and Narrative Politics. Unfortunately, for personal reasons, Lizzie Barnes is unable to join us today. We really do miss her, and I know she misses very much not being able to come today. As to the format of today's event, Brenda Cossman will speak about her book for about 25 minutes, and that will be followed by Tanya Serissier, who will speak for about 15 minutes. There'll be a time for additional comments by Brenda for a few minutes, and then we'll open it up for Q&A. And that Q&A will be moderated by my terrific colleague, Leila Ulrich, and she is a lecturer in law at the school, as well as the coordinator of the feminist reading group at the law school, and has done a fantastic job in pulling together this discussion and organizing this launch. My thanks also to Gulsh for our event, who is our events officer, for all the hard work put in publicizing the event. So without further ado, let me hand over the Zoom space to Brenda Cossman.
Wonderful. So just as I try to share my screen right now and get the slideshow going. Okay, so let me just start by thanking the organizers, Retna, Leila, and Tanya for being the discussant, Queen Mary School of Law for hosting this. It's a real honor to be here today. So, you know, when you're writing a book, it's hard to imagine you'll ever finish writing a book. And when you're writing a book, it's hard to imagine that anyone would ever actually read the book, partly because you don't think you're ever going to finish the book. So it is an absolute pleasure to be here today with the book that now feels like really very hot off the press. So I'm going to start with a few caveats. Oops, I didn't start my timer. Start with some of the limitations of the book, particularly given today's audience. I might consistently say this morning because it is quite early here in Canada. So with a few limitations about the book. So first, it addresses a very, very American set of debates in a very American Me Too context. And the debates are debates that are still very entrenched in what Alison Phipps has called the political whiteness of mainstream feminism, which is all the more ironic, yet sadly predictable, given Me Too's genealogy back to Tarana Burke. And this is something that I directly address in the book. In the book, I try to explicitly address these limitations. particularly the latter limitations around the political whiteness of the book, although not really the former, not really its really uniquely American context. And it's my hope that while the context is specifically American, the approach that I take to finding ways to move beyond or perhaps beside the debates may have a resonance outside of this American context. So the basic argument in the book is that when it comes to sexual harm, particularly the legal regulation of sexual harm, feminists have been having the exact same arguments over and over again from the sex wars of the 1970s and the 1980s, that they've been having the same arguments with the same underlying divisions and disagreements about sexuality, women's agency, and the role of law. Now, I started this project before the viral eruption of Me Too. I began to look at a series of feminist debates, contemporary feminist debates that were dividing along all too similar and familiar lines: sex work, so-called revenge porn, or the legal regulation of consensual, the non-consensual distribution of sexually explicit images. It's a mouthful, but it's a better term than revenge porn, sexual harassment, and sexual assault. And I began to call these newer debates Sex Wars 2.0, because I started to see in these feminist debates the exact same debates that were happening in the 70s and 1980s that were dividing feminists. And so I had started along this, this work when along comes October 2017, Alyssa Milano's tweet, which unleashed an astounding outpouring of women globally coming forward and saying, yes, it happened to me too. Within days, millions of women from 85 countries had taken to social media with the hashtag. Now, within a few days, Tarana Burke was credited with actually starting the Me Too campaign in 2006 to support Black women and girls who were survivors of sexual violence. But the hashtag movement took on a life of its own. While Tarana Burke was acknowledged as starting Me Too, the hashtag Me Too really took off in a different and a viral direction. Within weeks and months, powerful American men, Harvey Weinstein, Charlie Rose, Matt Lauer, amongst others, had lost their vaulted positions, their status, as stories about the sheer ubiquity of sexual violence proliferated. This is the only way I ever really put Weinstein up on the screen, is, you know, most of his face covered by Me Too, because I really can't stand looking at the man. But the massive outpouring of stories of sexual violence and harassment soon very quickly met with some pushback. Now, some of this would be predictable in coming from, you know, more conservative commentators, but it also took on a uniquely feminist turn. Me Too, and this was something that was seen, I think, a little bit globally, although of course it took very different turns in very different contexts. But the idea here was somehow that Me Too was going too far. Now, what anyone meant by too far really differed, but it was going too far. It was becoming a sex panic. It was becoming a witch hunt. It was becoming the death of due process. It was becoming the death of flirtation. It was doing something that was too much. And as I say, while these objections came from across the political spectrum, there was a distinctly feminist version that emerged, first in kind of whispers, sotto voce, but slowly gained some traction. And here on the screen are a couple of the more public faces of women, whether they're feminist or not, is itself a debate, but, you know, self-identified feminists who had real issues with Me Too, quote, going too far. So while this was starting to, you know, percolate up, in the US, it took on the debate hit a kind of frenzied pitch following the publication of a story about Aziz Ansari, an American actor. Now, the article published in an online journal, you know, not the highest form of journalism, but an online journal, told the story of Grace, a 20-something woman who went on a date with the actor, where he repeatedly initiated sex with her despite her discomfort and her request to slow down. She eventually leaves in tears to understand her experience as a sexual assault. So after the publication of this, the feminist blogsphere exploded. The story resonated for many women, particularly but not exclusively young women, but others denounced it as trivializing what Me Too really stood for. It obviously, to some, represented Me Too going too far again. Several self-described feminists writing in high-profile media, like Caitlin Flanagan in The Atlantic, Barry Weiss in the New York Times, provocatively condemned the article. The feminist debate was then very quickly framed as a generational one. It was millennials versus second wave feminists, and it quickly turned really nasty. Here's one of the highlights of the nastiness. Katie Way, who was the author of the Grace and Aziz story, famously called CNN reporter Ashley Banfield a burgundy lipstick, bad highlights, second wave feminist has-been. So, the gloves were off and punches were not being pulled. Younger feminists blamed second wave feminists for, well, pretty much everything. And second wave feminists told millennial feminists to grow up and learn how to call an Uber. It was game on, and it was nasty. Now, not all feminist voices joined in this generational narrative, but these voices were lost in the social and mainstream media alike, where the preferred narrative was really much more of a catfight between generations. And I discuss in the book just a little bit about the history of catfight narratives and how frequently in mainstream media, any debates between and amongst women or between and amongst feminists is put into this trope of a catfight as a way to both sexualize and trivialize the substantive debates. So my argument was that this generational debate, this generational narrative was not helpful in explaining the underlying disagreements. Now, admittedly, when you're a hammer, everything looks like a nail. But I saw the sex wars 2.0, exploding all over the place. The debate was not generational. It reflected the same fault lines around sexuality, around agency, around the role of law that have been dividing feminists for decades and for generations. It's not a generational war, it's debates that have survived generations. So the first part of the book tries to track these debates. Well, first I outlined just what I had said here, but then I try to track these debates going back over the sex wars of the 1970s and the 1980s with a particular focus on the role of law. In a nutshell, what I try to do there is outline the two sides of the debate. On the one side, radical feminists who argued that sexuality was a key site of women's oppression, that it was dangerous. On the other side, sex radicals or sex positive feminists who were critical of seeing sexuality only as a site of oppression. And so they divided on questions of sexuality as danger or pleasure. They then also divided around the extent to which women were victims or to which they had some degree of agency, particularly in relation to sexuality. And finally, in relation to the role of law. Sex radicals, at least in the later part of the sex wars, turned to law as a way to try to regulate, oh, another cat has arrived, as a way to regulate pornography, and the feminists on the other side, the sex positive feminists, were very skeptical, very critical of trying to use law in this way, given the way in which law has been used historically to regulate sexuality in ways that are deeply problematic. I'm sorry, I often have to move cats. So the first part of the book traces the original sex wars, and then it turns to the debates that were playing out in the context of sexual violence, particularly on college campuses in relation to, in the US, what's known as Title IX, and the extent to which these debates were now, as the article by Emily Bazelon had suggested in an article in the New York Times, had called this the return of the sex wars. And here we see two of the partisans in the contemporary sex wars. On the one side, Catherine MacKinnon, who was a partisan in the first round of the sex wars, but now Catherine MacKinnon lining up against Janet Halley, both of them from Harvard Law School. And what I look at here is how these debates around sexual violence in and on college campuses were actually repeating the exact same debates, and they were lining up the same way around views of sexuality, views of agency, victimization versus agency, and the extent to which feminists should or should not be turning to law. So that is what I do in the first part of the book. I then turn to having set out the sex wars then and now. I then turn my attention back to the Me Too feminist debates, and I try to then track the ways in which the Me Too feminist debates actually lined up with these earlier sex wars and the new sex wars that I identify in the book. So chapter 3 and chapter 4 come back to trying to do this. So again, this is in a nutshell and without a lot of nuance to the arguments that Me Too feminists lined up like the radical feminists before them in seeing and emphasizing sexuality as dangerous, where the feminist detractors wanted to also add not to the exclusion of sexuality as dangerous, but that sexuality is also potentially a site of pleasure. In terms of consent or agency, Me Too feminists, once again, like their radical feminist, as the inheritors of the intellectual tradition of radical feminism, there was an emphasis by Me Too feminists on women as victims, whereas the feminist detractors wanted to add sexual agency back to women, that they were not exclusively victims, they were victims, but they were also agents. They were sexual agents who had agency, and this would in turn lead to either broader or narrower notions of how we ought to be thinking about consent and defining consent. And last, and definitely not least, although probably the most complicated, was law and the different approaches to law. Now, in some ways, Me Too feminists were arguing for more law, feminist detractors for less law. This is more difficult because Me Too did not itself emerge as a movement about law. It was, in fact, a protest against the failure of law. In fact, I think it was a performance of the spectacular failure of law to protect women from sexual harm and sexual violence, and then to do anything about that sexual harm or sexual violence once it actually occurred. And so the legal story is, I think, a little bit more complicated because it didn't ultimately emerge as a story about law. So I had to, dig a little deeper to find out what Me Too feminists and the feminist detractors were actually saying about law. And I think that we do ultimately see Me Too feminists arguing for broader definitions of sexual harm, more robust notions of consent, and better enforcement of law, including the criminal law. Feminist detractors, on the other hand, were more skeptical about the use of law, particularly skeptical about the use of criminal law because of the history that has been shown now around who is hurt through the enforcement of criminal law, and what we see particularly in the United States, although it is a phenomenon well beyond that, which is the racialization of criminal law in the United States and the mass incarceration of people of color and men of color. So the carceral critique that has emerged in recent years, alongside the critique of the racialization of the criminal justice system in the United States. And so the feminist detractors then were a bit more interested in narrowing some of the definitions as opposed to broadening them, not particularly enthusiastic about criminal law, but to the extent that criminal law was going to be used, then very insistent on things like due process protections, precisely because of the fear of who would otherwise be punished in the absence of these due process protections. So a slightly more complicated vision of law here, but one that did still, I think, track previous debates in very significant ways. So that's what I do through the third chapter. The fourth chapter, I take a little bit of a turn that brings the lens of queer theory to Me Too feminist debates. And here I turn to a particular controversy that emerged, again, very American context, that emerged when NYU law professor Abitel Ronell, who identifies as queer, was accused of sexual harassment by her gay graduate student, Nimrod Rietman, sorry. And this, of course, exploded, front pages of the New York Times, the Washington Post. Oh, what happens when a feminist is accused of sexual harassment? And it was, sort of being used to illustrate the hypocrisy of Me Too and the hypocrisy of feminists, when suddenly if it's a woman accused, then everybody runs to her defense. By everyone, we mean, feminists run to their defense. Now, that was not entirely true. Not everyone did run to her defense, but some people did. Some people also worried about the way in which sexual harassment policies can be twisted and turned, particularly against either feminists, but those who identify as queer. And so this was being seen as an example of some of the dangers that can happen when sexual harassment policies are written so broadly, when you put that on top of a history of targeting, legal targeting of queer people. There was a concern about how this was playing out. On the other hand, there's definitely a concern as the facts came out about really, really deeply problematic treatment by the professor of the student. Now, when this erupted, it was also framed as a kind of a different generational narrative. And now it was kind of like graduate students and those who were like low-level contract teachers up against senior, tenured, established academics. And again, I argued in a slightly revised version of the Sex Wars that it was more productive to see this through as a debate between different feminist and queer theories, a slight twist on the Sex Wars than it was to see it in terms of a generational debate. Now, then I try to shift. So having done all this tracking, I then try to shift my focus to, okay, here are the debates. We're having them over and over and over again. And as much fun as they are, really, it's time to stop. But how might we do that? So then I turn to trying to think about what we can do about it. How can we break out of the problem of kind of infinite regress of these sex wars? Sex wars that also get really nasty. Each iteration of this, each iteration of the Me Too debate got really nasty. The Abitel Ronell controversy got really nasty in the same way that the initial debates are really nasty. There is a deep, deep emotion and affect that characterizes these debates. That makes it also, the people on both sides get that much more entrenched in the affect of the disagreement as well as the disagreement itself. So how might we break out of this? How might we think differently about regulating sexual harm? And how might we think differently then about these debates? So here I turn to the work of Eve Sedgwick, and particularly to her work around paranoid versus reparative readings. And I find real inspiration in this work. So her idea of reparative reading, in a nutshell, is instead of always looking for the meaning underneath the text, sometimes we should look to what is right there in plain sight. Paranoid readings, we're always looking beneath the surface. We're always looking for what the text really says when it doesn't actually say that. Why don't we look to see what is right in plain sight? And we should also try to, quote, read beside each other. She says, beside is an interesting preposition because there is nothing very dualistic about it. A number of elements may lie alongside one another. So what might be revealed if we read the feminist claims beside each other? Instead of treating the debate as dichotomous, one right and one wrong, what might we see, understand, feel if we accepted the truth claims of both sides and held them in tension beside each other, rather than just assuming that we have to pick a side? So, and here I use this image of the bunny and the duck as my way of thinking about reparative reading. So we can hold two sides beside each other. You can only see the bunny or the duck. You can't see them both at the same time. Except when you see the bunny, you know that the duck is there. When you see the duck, you know that the bunny is still there, even though you cannot actually see them at the same time. So I try to go back to Me Too, the Me Too debates and the broader debates around sexual harm with this in mind. And now, at the risk of being overly reductive, one of the ways that I then ultimately frame the debates is, on one side, Me Too feminism was really, really concerned about underregulation and the extent to which the harms of sexual violence remain unaddressed by law. The feminist detractors, on the other hand, are really concerned about the overregulation of sexuality and the harms of criminal law and carcerality. So what happens if we try to read these two beside each other as opposed to against each other? What if we interrogate both the over and the underregulation of sex, recognizing that they can both be valid? So reading reparatively on the surface, seeing what is in plain sight, taking the intensity of the effective claims seriously, we can actually acknowledge both the harms of overcriminalization and the harms of non-consensual sex. These are assumed to be at odds, but that is only if we think that it is only possible to redress sexual injury through the criminal law. So one of the things that I then do is really make an argument for bracketing the criminal law and decentering the criminal law and starting to think about other modes of regulation. We are lawyers, and it is possible, criminal law tends to be the knee-jerk go-to, but there are many, many other modes of regulation that I think we might be able to think about. So I argue for
2 minutes, Brenda.
Okay, so here I argue for reading the debates beside each other, displacing the centrality of the criminal law, looking for alternative modalities of regulation, particularly alternative modalities that can recognize harm, promote accountability, and cultivate repair. And it's here that I also turn back very specifically to the work of, and I try to recenter the work now of Black feminists, particularly abolition feminists and their critique of the carceral state, mass incarceration in the United States, and really try to build on that work, and really then try to bring the other Me Too movement, the non-hashtag Me Too movement that is tracked back to Tarana Burke, and try to recenter that, and propose a reparative approach that builds on those insights. So in the concluding chapter, and I can talk about this a bit more in the discussion, but I return to the question of emotion, particularly to the emotion that attaches to disagreement, to the role that anger plays in our disagreements, and to think about how to better craft our anger. And again, drawing very heavily on the work of Black feminists and returning to where Me Too started, not the hashtag, but with Tarana Burke. Tarana Burke herself speaks to the need to move beyond anger, and the need to, what she talks about, cultivating joy. And she talks about, not getting stuck in our anger, but leaning into repair, to healing, to resilience, and to joy. And it's in relation to this reparative approach to both feminist debates and to the regulation of sexuality that I hope the book might have a broader resonance beyond its very American context. Because I think the seemingly intractable feminist debates with more than a little anger and hostility is not an exclusively American phenomenon. So let me stop there. I think I'm 50 seconds over.
No, you're fine. Terrific. Thank you very much, Brenda. Let me now hand over to Tanya for her comments.
Okay, sorry, I'm just setting my timer as well.
And I'm going to try to take my screen down now.
I think it's gone.
Is it? Okay.
It's gone.
Great. Even better.
All right. So I wanted to start by saying thank you so much to Brenda and to Ratna and Layla for giving me the opportunity to respond to this book. It's no exaggeration to say that for me, it was the best book that I've read in a long time. I really loved it. I think it's the best intellectual history of the sex wars and treatment of feminist conflicts, up to the present day that I've read. I really think that I learned a lot. I thought differently about things, and I have so many questions that I'm really going to have to try to compress my remarks. And I think those are the best things that you can say about a book. For me, if I want to restate kind of what I took away from the book and the kinds of lessons that it gives to us today, it treats these questions through this historical examination of the sex wars and Me Too, but it's really asking, what should feminists do or call for about sexual harms, and how might we deal with complex issues in less polarized and constructive ways? And really crucially, as Brenda said, what role should law have in this? And I think another question is, what role do feminists want law to have in this? And why are the answers to these questions often different? So I want to focus on a couple of areas, the law, to talk a little bit about the value, I think, of the historical account and some of the things that I took from it, and to go back to where Brenda finished on reparative reading. And hopefully I will get through all of that in the 15 minutes that I have. So in terms of the reading of law, in thinking about the sex wars in the context of the 1980s, one of the most important things for me was that this is a far more complex picture of the relationship to law of this period than you usually see. And particularly in terms of talking about the kind of anti-pornography feminist, the radical feminist side, and at one point Brenda says the schisms ascribed to the feminist sex wars were in fact dividing anti-pornography feminists themselves. The speakers agreed on the analysis of pornography and sexual violence, but they disagreed on the question of law. And she illustrates this in a really interesting way. Feminists who left groups because of the emphasis on censorship, feminists who changed their mind. And I think seeing that in itself actually opens up that question of intractability, and also the way that law becomes more and more fixed as a part of these debates. Because I think, if it opens up this question of law as a source of discord among anti-pornography feminists, it also shows that law was not the original preoccupation either of sex radicals. And it becomes that as the conflict becomes more and more entrenched. And it seemed to me reading that that's actually one of the ways in which the sex wars 2.0, and I want to think a bit about that 2.0 in terms of going back to Butler, as well as this is kind of an iterative repetition that, as Brenda says, in many ways it reflects ongoing and repeated debates, but it does them in slightly different ways. And I think one of the things that we really see in the book is the way that the law becomes an increasingly kind of all-encompassing horizon to these debates. And that in the last kind of decade or so, there are a lot of assumptions made about the role of law and where it sits within these debates that Brenda shows weren't there in the early 1980s particularly. And I think even the fact that when you look at the kind of two representatives figures in the book, we have Catherine McKinnon, we have Janet Halley, we have two law professors, this is a shift in and of itself. And, so then we have the question when we get to the present, what does Me Too feminism want from law? And I think we could also ask, why is it that Me Too feminism structures its desires and demands more through law and legal horizons than the feminist antecedents? What do the opponents of Me Too feminism want from law? And again, why are those demands structured more through law than their antecedents? And this is a question, I think, that goes beyond Me Too to a lot of contemporary feminist activism. And it's a really interesting point that the book opens up. And as Brenda says, where the book finishes is with this question of loosening the hold of law. And one of the tools it gives us, I think, to do that is to look at how that hold has become more and more restrictive over the past decades as we've looked. So to talk then a bit more about the 2.0 framing, I think, you know, the new sex wars, and Brenda does often refer to it as 2.0, the historical account offered, you know, is in many ways a lot more progressive and gradual than this. We go from the 1980s through the feminist flashpoints and upsurges in the 1990s, the 2000s, and up to the present day. And so I think what the book makes clear is that even though we have these two, you know, really important moments, you know, they are in a kind of history of media studies, not, you know, a new thing or something that went away and came back, but tensions bubbling along that surface at particular points in time. And so it's looking at the ways that they surface and why at particular moments. And so in that, I did actually think about this question, as I said, of looking at the differences within the similarities as well. And I think the book draws both of these out. And so the first one is this kind of capture of feminist imagination by law. And then the second one, the book deals a lot as an intellectual history, and I think that's one of the projects of it, with intellectual inheritances. And so I was interested then in this thinking of kind of Me Too feminists and also the student activists around Title IX as the inheritors of the earlier radical feminists, and then people like Janet Halley and other prominent opponents both of Title IX and some of what, you know, they argue as the excesses of Me Too, like Laura Kipnis, and the ways I think that they take those intellectual inheritances in different directions, in the same ways that there were actually these different positions around law, for instance, in the anti-pornography feminists. And, you know, so one question I had was, if we start to open up those kinds of differences too, and particularly I think if we look at contemporary, what we might call kind of Me Too and Title IX feminists, I think that there are still a lot of differences there between, for instance, how a lot of student radicals around kind of calling for Title IX regulation would actually express support for less restrictive laws on pornography, would be very supportive of decriminalization of sex work, whereas some of the kind of celebrity feminists around Me Too are actually, you know, very pro the Nordic model, very anti-pornography. I think on the other side, if we look at the figures of Janet Halley and Laura Kipnis, again, I think they pick up strands of that earlier politics, but they also take them in different directions. So I think Halley is particularly, you know, interested in questions of law and due process and thinking about Me Too as needing to offer those protections to everyone. The reading that Kipnis makes, I think, is a little bit different in that she doesn't necessarily reject punitivism, but she argues that it's been kind of pointed in the wrong direction. And so, you know, she's talked a lot of times, actually, there's a lot of quotes from her where she says, you know, for genuine sexual predators like Harvey Weinstein, you know, she thinks jail is not enough. She's a supporter of chemical castration. But what she thinks is that, you know, the kind of gaze, the focus of Me Too is pointed to the wrong people, the people that it shouldn't be. And so I think, you know, there's a question there about whether, in a sense, you know, you do want to offer legal protections to everyone, or, you know, in what has been an ongoing critique of carceral feminism, and I think Laura Kipnis is an example of this, actually you just want to make sure that the carceral system continues to point its gaze at those that you already consider to be deviant and other, the kind of proper objects of the criminal law. And I think that comes up in the book in terms of talking about how there's more than one way to critique the law. And I think, you know, that's a really important point, that even within these kind of new divisions, we can see complexity, we can see an unraveling between them. And I think with that, the kind of reading practice that Brenda offers is so important for that, like moving beyond those kinds of binaries. Okay, so another point that I'm particularly interested in, actually, that I think isn't a major explicit theme of the book, but actually occurs throughout it, is this relationship between legal and cultural regulation. And this begins again with thinking about the kind of anti-pornography feminists and the shift from a strategy that was mostly around kind of boycotts, marches against pornographic cinemas, actually thinking about being civil actors in civil society and operating in that way through then Dworkin and McKinnon, even though they insisted it wasn't censorship, to a strategy that many, including many of their kind of allies and former allies, saw as censorship. And it was interesting to me because I think, again, it wasn't something that I had thought of, but that is clearly a direct link through to the practices of Me Too, particularly in the early phase in terms of thinking about media companies responding to complaints. And, there's, I think, a kind of question there that we can pose about to the extent to which this is doing a move away from carcerality, or in a quote that is in the book from Lisa Duggan, we're talking about a shift from a neoliberal carceral feminism to a more privatized version of feminism that isn't necessarily less punitive, but relies on corporate boards rather than the state to dole out consequences. And I think we probably see a little bit of a shift between those two poles in the more kind of punitive elements of Me Too. And I think one of the other things that the book does really brilliantly is articulate how on both sides of the debate, law, legal processes, legal imaginings, have come to dominate wider understandings of fairness and of justice. And a kind of very brief example of that is the discussion of due process, and the way that due process in public debates around Me Too has really migrated into something that goes beyond, what everyone is entitled to in the courts, to a kind of fluid cluster of notions that cover everything that people see as unfair, as abuse and oppression. And the way that framing can only ever bring us back to the question of law and legal solutions. It doesn't really open up wider understandings of what fairness might be. And so just to finish up, the methodology of the book means that it enacts and offers a model of what it argues for, which is part of what makes it really, I think, quite a brilliant book. And it's also one of the most kind of thoughtful examples of reparative reading that I've seen beyond Eve Sedgwick and people like Rita Felsky. And it was thinking about Felsky that also made me think about, other resonances between the critique that the book offers of the carceral and the methodology, is that Felsky has this kind of wonderful metaphor of the paranoid critic as a detective, who's always looking to find a criminal, to find a crime, to expose and to punish. And, for her, if we can get over our kind of punitive senses of reading, that will help us to read in more kind of open ways. And she does that following from Felsky. And the resonance of that in terms of thinking about how we as feminists might actually begin to have, healthier, different modes of engagement, I've just found incredibly useful, and the book doesn't shy away from the fact that, asking us to engage reparatively with each other, to do so in a generous way is incredibly hard, particularly when it feels like so much is at stake. And reading the book, it made me reflect in my own way. And Brenda talks a little bit about being a participant in earlier iterations of the sex wars and trying to step back, that it is often easier to do that generous reparative reading when you're talking about things that are kind of 10, 20 years ago. And the attempt to do that now about the contemporary in this book is so useful because, for me personally, it's very easy to look back at figures like Andrea Dworkin and her role in the 1980s and find it both kind of, awful, but able to appreciate the brilliance of some of the things that she did. And it's that distance, but actually engaging in that practice of reading in the contemporary, in the here and now, pointing to alternate solutions, I think, is so useful. And I think that's where the book really leaves us with Sedgwick's promise that this kind of mode of reading, this kind of mode of criticism gives us the room to accept and realize that the future might be beyond and different from the present, that it doesn't have to be contained by where we are now. And so I think, thinking about this as a model of practice, of a way of starting to try to think about harm, injury, and how we might respond to them differently. Yes, I would really recommend that everyone reads it, because I took a great deal away from it. So thank you.
That was terrific. Thank you so much, Tanya. Brenda, you have some comments or remarks that you'd like to make?
Other than to say, oh my God, thank you. That was, I'm a bit speechless. Thank you, Tanya. And I'm a bit speechless only because it's so interesting to hear someone else talk about what the book is about. And because, you know, you kind of lose track of what the book is about. When you're inside of it, you don't see the forest for all the trees. And so that was just like such an incredible engagement with this. And, you know, what I really, what I didn't see, and yet it's so obvious, is the way you just said that that it really brings out the extent to which the feminist imagination has been captured by law. And I really, really appreciate that. And I think that it is a real problem, because, and there's reasons for it, right? There's reasons that feminists have turned to law to get various harms recognized. To make them legible is to make them judiciable. And they have to be legally legible in order to really be recognized as harms. And so it was a whole discursive strategy by feminists to actually turn to law to have something be recognized as serious. And yet that has led to this broader captivation of the feminist imaginary with law. And so I find that comment was just absolutely really helped me think about what my book is actually about. And, you know, and I really did try in the book to focus on, because, you know, I am another one of the law professors, to really focus on what the role of law has been throughout this, because I think that, you know, many of the intellectual histories that have been told haven't focused on law, what the role of law is. And, you know, when I went back and I delved back into the debates of the 70s and 80s, and even through the ones of the 90s, you could really see, well, both, you know, going back and reading the original archives, the anger of them was really profound. And the anger that came from almost the shock of betrayal that came from disagreement. And I found that really personally fascinating, but I had to dig really deep to find what they were saying about law, because a lot of them, they weren't lawyers and they weren't law professors until suddenly they were, you know, and later in time, suddenly those are the folks who are really dominating. And even, you know, the student activists. So a lot of the student activists who started when they were in undergrad, being involved in the various, you know, Know Your Nine, No Title IX, and so on, they all go to law school. They all end up in law school. It's really fascinating, the sort of the hegemony of law here. And then, you know, I worry about the hegemony, particularly of criminal law. You know, and I do think that we have a very strong knee-jerk reaction that there ought to be a law. And if there ought to be a law, it ought to be a criminal law. And even when we turn to civil law, so, you know, Title IX is not criminal, but then it has a kind of carceral criminal logic to it. We want punishment. And then we have to think about what is the appropriate punishment. We're not looking for accountability and responsibility and healing. We're looking for punishment. And so, you know, I'm really interested in trying to move away from that framing without giving up on law. Because, you know, I'm like, well, it's what I know, even though I think that we do need to decenter it. And try to think otherwise. Anyway, that's enough. I feel like I'm just, you know, sort of, I'm really just thinking out loud, but I just so appreciate those comments and that engagement. And just thank you so much.